Ready? Exercise number 11. Start. In the counter affidavit filed by the state, the respondent number 1 has not denied the aforesaid averments that management had sent papers regarding selection of the petitioner to the DIOS Jaunpur on 29/9/1993. However, the DIOS did not pass any order or communicated his decision within 7 days. As such, in view of Clause 3 of Second Removal of Difficulties Order, the DIOS will be deemed to have given his approval. Stop. Next para. Thus, the impugned order passed by DIOS cannot stand the scrutiny of law, and the view of DIOS Jaunpur cannot be sustained. It cannot be said that the appointment of the petitioner in the post of lecturer in history in short-term vacancy is contrary to the provisions of Second Removal of Difficulties Order. The impugned order dated 18/10/1993 is hereby quashed. Let us now proceed to examine the second prayer made by the petitioner in the writ petition, which is as under. Quote next para. To issue a writ order or direction in the nature of mandamus directing the respondents to make payment of salary to the petitioner regularly along with all arrears on that account. Stop. Next para. It has not been disputed by the respondents that Raj Bahadur Singh, the lecturer in history (ad hoc principal out), also retired on 30/6/2003. As such, vacancy of lecturer in history became substantive. Stop. Next para. It has been vehemently argued by learned counsel for respondent number 2 that in view of the full bench decision in the case of Pramila Mishra (Deputy Director of Education, Jhansi Division, Jhansi and others (1997) out to UP LBEC 1329. Petitioner, who was appointed on ad hoc basis in a short-term vacancy, has no right to continue against substantive vacancy after the short-term vacancy of lecturer in history converted into a substantive vacancy on 30/6/2003. The full bench in the case of Srimati Pramila Mishra out has held as follows. Quote next para. Summing up our conclusions in the light of the discussions in the foregoing paragraphs, we hold that a teacher appointed by the management of the institution on ad hoc basis in a short-term vacancy (leave vacancy / suspension vacancy out), which is subsequently converted into a substantive vacancy in accordance with the provisions of the Act, rules and orders on death, resignation, dismissal or removal of the permanent incumbent out, cannot claim a right to continue. He has, however, right to be considered along with other eligibility candidates for ad hoc appointment in the substantive vacancy if he possesses the requisite qualifications. Consequent upon the view taken by us as noted above, we hold that the decisions of this court, like Kumari Meena Singh's case out and other cases taking contrary view, are declared to be no longer good law. Stop. Next para. It has not been disputed by the respondents that Raj Bahadur Singh, lecturer in history, who was promoted on ad hoc basis to the post of principal in the institution, has now retired on 30/6/2003. As such, short-term vacancy of lecturer in history in the institution has been converted into a substantive vacancy on 30/6/2003. Therefore, in view of the full bench decision in the case of Srimati Pramila Mishra under bracket supra bracket out, the petitioner did not have any right to continue after 30/6/2003. It has also come on record that this substantive vacancy was also notified to the selection board and one Ajit Kumar Singh was selected by the selection board. Although the legality of the appointment of Ajit Kumar Singh in the institution is sub judice before this court in writ petition number 4734 of 2009. Therefore, since the matter with regard to the appointment of Ajit Kumar Singh in the institution is under consideration before this court, it is not desirable to make any observation in this writ petition regarding the claim of Ajit Kumar Singh. However, as already held herein above, after the retirement of Raj Bahadur Singh, short-term vacancy on the post of lecturer in history has been converted into a substantive vacancy on 30/6/2003. Therefore, the petitioner cannot claim any right to continue after 30/6/2003 in view of the aforementioned full bench decision of this court. Stop. Next para. Summing up my conclusions in the light of the discussions in the foregoing paragraphs, I hold that the initial appointment of the petitioner on ad hoc basis to the post of lecturer in history was on short-term vacancy in accordance with second removal of difficulties order 1981. Thus, the initial appointment of the petitioner dated 10/10/1993 is held valid. However, when the short-term vacancy in the post of lecturer in history was converted into substantive vacancy on 30/6/2003 after the retirement of Raj Bahadur Singh, the petitioner ceased to have any right to continue on the said post. As such, the continuance of the petitioner in the institution after 30/6/2003 cannot be said to be legal or proper in view of the full bench decision of this court in Pramila Mishra under bracket supra. Even though the petitioner had no claim to continue in the post of lecturer in the institution, the salary or any remuneration paid to him, however, may not be recovered. Henceforth, the petitioner will neither be entitled to continue in the post of lecturer in history in the institution nor to any salary. Full stop. Thank you very much. Guys, there is one humble request. Again, I am requesting, please always try to repeat the matter, then only your fluency and accuracy on shorthand will improve. And also there is one more request. If you found the matter is excellent, you can give your valuable comment on my YouTube channel. And also for next audio, please subscribe my channel. Thank you very much.